Hello everyone, welcome to Courts Today by LiveLaw. I'm Debojit Das and we have the day's headlining stories from courts across the country ready for you. So, let's begin. Starting with the Supreme Court, where the Delhi police took a firm stance in the Supreme Court, opposing bail for Umar Khalid, Sharjeel Imam and others in the Delhi riots' larger conspiracy case, primarily under the UAPA Act. The core of the police's argument stated in the affidavit is highly adversarial. They assert that the petitioners are trying to play victim card on the grounds of prolonged incarceration. The police contend that the accused themselves are responsible for the delay in the trial through malified and mischievous reasons, thus disentitling them from bail based on delay alone. Beyond the delay issue, the police detailed the larger conspiracy, claiming the petitioners' actions, including conceptualizing a chakka jam, were intended to strike at the sovereignty and integrity of the country. The affidavit suggests the plan was to instigate an armed rebellion that was sought to be replicated and executed pan-India. The affidavit names Umar Khalid as the chief conspirator and outlines specific roles for each accused, claiming they organized, financed, and escalated what began as anti-CAA or NRC protests into violent riots. Ultimately, the police argued that no liberty of bail can be granted for committing a heinous offense of highest order. Next, the Supreme Court took over the task of clarifying an important principle in evidence. Imagine a victim of a crime knowing they are about to die names their attacker. This is what we call a dying declaration, and it's often critical evidence. The problem in a recent Supreme Court case where the victim made 3 different declarations before passing away, and they had minor inconsistencies. The accused woman, convicted of setting the victim on fire, argued that these discrepancies should lead to her acquittal. The Supreme Court, however, dismissed her appeal and upheld the murder conviction. The court held that if the first dying declaration is reliable, spontaneous, consistent, and corroborated by the independent evidence around it, then that initial statement is paramount. Minor variations or inconsistencies in later statements, perhaps due to deteriorating health or pain, do not weaken the core, truthful account given in the very first reliable declaration. The legal principle is clear. A solid, well-corroborated first statement stands strong, even if subsequent ones waver slightly. Moving away from the Supreme Court now and taking a look at an important development from the Bombay High Court, where the Bombay High Court's Nagpur bench took suo motu cognizance, meaning it acted on its own based on news reports here, regarding a major public inconvenience. Former MLA Om Prakash was leading a farmers' protest that had completely blocked National Highway 44. The facts highlighted in the news reports and noted by Justice Rajneesh Vyas showed extreme suffering. Travelers faced massive 20-kilometer traffic jams, crucial services were impacted, including the movement of ambulances and police vehicles, and the blocked highway provides access to the Nagpur airport and the National Cancer Institute. Crucially, the police had only permitted the protest for one specific day, that is October 28th, and at a different location. The continuation of the blockade without permission was a key fact leading to the ruling. The High Court was proactive, ruling that while the right to protest exists, it cannot violate the fundamental right of citizens to move freely. The court ordered Bachchu and the protesters to immediately and peacefully clear the site. If they failed, the police were directed to take strict action to remove them and restore traffic flow to normalcy. Next, we have a case from the Allahabad High Court involving a criminal complaint filed against former India Today editor Prabhu Chawla and editor-in-chief Arun Puri regarding their 2003 report, Ladkiyon Ki Mandi, which documented the sexual exploitation and trafficking of minor girls. The complaint, lodged in 2004, accused the editors of defamation and violating Section 153A of the Indian Penal Code, which prohibits promoting enmity between different groups. The complainant argued that the article, specifically its references to the sale of girls to Hajj pilgrims, caused unrest within the Bedia community. The Allahabad High Court intervened and ultimately dismissed all criminal proceedings. The court decided that the purpose of the article was to expose child trafficking and abuse. The judges held that to sustain a charge under Section 153A of the IPC, the prosecution must prove a deliberate and malicious intent to incite hatred, a factor the court found lacking. By concluding that the publication fell within the bounds of the fundamental right to freedom of speech and expression, the High Court quashed the charges and closed the long pending case. Next, we have a story from Karnataka on Praveen Kumar, a government employee working as a personal assistant to an MLA who was suddenly placed under suspension. The reason? Allegedly participating in the centenary celebrations of the Rashtriya Swayamsevak Sangh on a Sunday while wearing an organization's uniform. The suspension order was based solely on a third-party television news report and was passed under the Karnataka Civil Services rules. When the employee challenged the order, the Karnataka State Administrative Tribunal took immediate action. The tribunal noted the applicant's argument that the suspension was issued in haste and without proper application of mind. The central question raised by the tribunal was how participating in an apparently a private non-political event on a non-working day could justify immediate suspension under the civil service rules. The tribunal granted an interim stay on the suspension order, ensuring that the employee's immediate reinstatement while the case proceeds. Moving on to another significant ruling from the Delhi High Court that strongly affirms the autonomy and fundamental rights of teachers' bodies against administrative overreach. The conflict began in November 2022 when Jamia Millia Islamia issued a series of office orders that dissolved the Jamia Teachers Association, sealed its office, and barred its members from holding meetings. The university essentially claimed the right to dissolve or restructure the JTA or the Teachers Association, arguing that its power stemmed from the Jamia Millia Islamia Act of 1988. This move effectively crippled the teachers' representative body and was seen as a profound attempt by the administration to interfere with the association's internal affairs, leading the Teachers Association to challenge the action in the Delhi High Court. The Delhi High Court, led by Justice Sachin Datta, decisively quashed the university's orders, calling them administrative in nature, bearing no rational nexus to any legitimate regulatory purpose. The core of the judgment rested on the fundamental right to association, guaranteed under Article 19(1)(c) of the Indian Constitution. Justice Datta emphasized that the JMI Act's powers must operate within the bounds of the Constitution and cannot be used to override or curtail fundamental freedoms. And our final story of the day is about a case that began with the horrific 2007 Rampur CRPF camp terror attack, which killed 8 people, including 7 Jawans. The trial court later convicted 4 men, including 2 Pakistani nationals, for the main charges like murder and waging war against the state, and sentenced them to death. However, the Allahabad High Court, specifically a bench of Justices Siddharth Verma and Ram Manohar Narayan Mishra, recently overturned those death sentences. The judges stated that they were deeply concerned with the magnitude and enormity of the offence, but were constrained to observe that the prosecution miserably failed to prove the case against the accused for the principal offence beyond reasonable doubt. This is the key takeaway here. The court found that a defect in investigation went to the root of the case, meaning the police probe was so flawed that it could not reliably link the accused to the primary terror and murder charges. While the accused were acquitted of the most severe offences, the High Court did find them guilty under the Arms Act, that was for possessing illegal weapons, and sentenced them to 10 years. Since they had already spent over 17 years in custody, their sentence was considered served, leading to their release from the main conviction. And that's a wrap for today's segment of Courts Today. But if you want to delve deeper into any of these stories and more, visit www.livelaww.in and keep following all our socials to stay updated with everything that is law. I'm Debojit Das. Thank you for watching.